Hello, hello. It is Wednesday. We are Debate Sensei. We got Tim Seavey from University, the San Diego one, right?
It's the state one. So we're not the fancy one. We're not the smart one. But we're the good debate one.
All right. I am your communications professor, Jared Miller.
From the other side of the country tonight.
Yes. I'm in Virginia, so it's a little later than normal. So I'm visiting some family out here. They're letting me use their little office, so it's going to work out just fine.
And I understand that Matt is trying to discover his inner child tonight.
Yeah.
I think that was what he said. He's like, sorry, guys, I can't make the broadcast. But, best of luck to him. I dig the mug.
Yes, self-care. Self-care. There you go.
So what are we talking about tonight?
Okay, we are talking about the first round of the Jannese Davidson Memorial Tournament at Concordia University in Irvine, which is about term limits for Supreme Court justices. But not only that, but a constitutional amendment for term limits. And I think that's an interesting burden to put on the affirmative. But I didn't want to get too much into the negative strategy. I think it just makes more sense going affirmative first. Maybe we should try it first someday.
As a resolution, though, because we are currently in the thick of it for the SDSU Gasky Memorial Tournament coming up, we're in the thick of writing resolutions and stuff, and it's tricky to acknowledge as a tournament director that if you burden the affirmative side with like an impossible position, the debate's over right away. Like if you give a bad topic. So if they were to just say like, Congress should pass a bill that says term limits, that actually wouldn't function, right? Because like Congress doesn't have that ability. Congress doesn't have the ability to create a law limiting
let's talk about that then.
At least that's my belief, because it's like that would be an unfair check and balance, right?
I saw something about. Oh man, there's a website that's pretty good about this, a Fix the Court one, and there was a bill that was introduced. Oh man, where was it? I think that there was so at the very least, there was somebody who introduced a bill into Congress for that. I'm wondering if that opens the door for like questioning, like, is it necessary to have a constitutional amendment? I think that's a really important question to answer just on the sort of tactical side of it, because it just kind of gets like, you're kind of getting bureaucratic at that point. You know what I mean? And I think that kind of avoids some of the other arguments that people are looking for you to have. But at the same time, I'm intrigued by any strategies. So it does intrigue me that somebody did introduce a bill for term limits for the Supreme Court. And so what I would do is go take a look at the original wording, and it just says that the judges and both in the Supreme Court and inferior courts shall hold their offices during good behavior.
What?
And shall at times, receive for their services a compensation, like good behavior.
What does that even mean?
Yeah, it didn't say a life term. Maybe at the time they kind of meant a life term when he said that you get to have this job as long as you are good, but it doesn't necessarily mean that it means for life. That just means like you won't get fired until your term is up if you have good behavior.
What you were just quoting was
the wording of the Article 3 of the Constitution, right? And so, and now I'm really wondering what sort of precedent there is, and I just didn't have enough time to do that sort of research. But that would be the next thing that I would do if I had any sort of amount of time. But if I didn't, that would be it. You know what I mean? Especially on the neg, I'm like, okay, maybe I could build something out of, just doing a bill for some reason. And usually what I would do is have like a critical position about why asking, like having a discussion about a constitutional amendment is setting yourself up for failure. And I think the better proposal is this one, and that's why you should back it. It is a better proposal. You know what I mean?
Okay.
It's more, I think that you have a much better shot of getting this accomplished.
I just feel like it's a little bit like fiat abusive to fiat a constitutional amendment, because that takes 2/3 of Congress, or is it 3/4 or 2/3 of the states? It's a supermajority of the states' votes as well, which is like no election has ever gone. I mean, I shouldn't say that. I don't believe that the states have passed any of the existing amendments to the Constitution of the United States. I think all those amendments have gone through Congress, and even still it requires like a supermajority.
Yeah, like I don't think it'd be fiat abuse. You know what I mean? If we're the way I look at debate is that it is like an exercise. I'm like, look, I'm going to throw something at you, and you do the best that you can. You're on the affirmative, you're on the negative, right? And so if I say, it's like, listen, you have to defend that a constitutional amendment would be a good thing. That's all you have to do. It's not necessarily say like, you don't have to do it. Like, let's stay away from which countries would vote for it and what that would mean in a real politic world setting. And just think about, if we have this amendment right now in some, really weird sort of like, like drama series on Netflix, and the premise was this, this amendment now exists, what might we see in that series? That's how I always look at debate. You know what I mean? It's kind of like just give me the premise. Fiat is just you suspending your disbelief enough to have a discussion, just like you do in science fiction, and just like you do in fantasy. You know what I mean? It's like people have disagreements, but they're still within that universe. And so I think that's a nice little exercise,
Okay. So if we went down that route, a constitutional amendment, I would at least claim, has a stronger backing to it. So that means that either a significant portion of the population or supermajority of Congress like really believe in this, and therefore it's more likely to stick because it represents either the will of the people or like a plurality of both sides of the aisle.
See, that's the thing, though, that at the same time,
I know I get that's getting.
Yeah, I'm not going to abuse. Yeah, I think that's when it starts becoming fiat abusive. You know what I mean? It's kind of like, okay, now no. It's like, no, people still disagree just as much as they do now. But there's this amendment. That's how I think the best way of thinking, like, because I think that takes away legitimate ground from the negative. You know what I mean? It's like, I think, and I do respect, like, if you're going to play the fiat game, then you got to respect the ground. You know what I mean? It's kind of like that's their ground. You're taking their story away from them, and so it's like who tells a better story. So I would go with like a sort of a politics story and maybe a mental health one. I was even thinking about how, like so far we've kind of gotten lucky with people retiring before like things start setting in, you know what I mean? But like, we're just going to leave that up to people's personal judgment? Like, like when we're, I think we're playing with fire here, right. In that situation. So,
yeah. And I suppose you could even make some kinds of claims of like, do you get into issues of ageism where people just start disagreeing with or start, issuing the beliefs and therefore judgments of particular justices just because like they are over a certain age or something like that. So if there were a term limit, that may help combat a little bit of that.
Well, now, if it was natural and if the terms were shorter, then we wouldn't have to worry about it. But it's like the average term for a Supreme Court justice is 28 years. That's average, right? And it's like, if you start at 50, which I don't know what the average age when they started, but you have to build a career of some type in order to get nominated. That takes a long time as well. Like you've got to be about middle age once you like, I don't know of anyone who was less younger than that. Right. So yeah, you're getting right into that age where it could be a problem. You know what I mean? It's like, so I think it's just, if you, I don't know. I think that,
Yeah.
like just you're leading up to an individual and not some sort of like. This way, we don't have to get into the ageism argument. Anyone could be nominated at any age, and
All right, we'll just go the straight affirmative strategy then. So there's maybe like one piece of the advantage, but that wouldn't be something that I build my case on. Up the middle, I think your argument comes down to more regular turnover of justices allows for a greater or a closer, hopefully, closer representation of the electorate. Like when you have justices that were put in office in the 1980s and they're still on the court, odds are, or I suppose we are to make the argument that their beliefs and therefore their resounding highest court in the land judgments are not particularly reflective of the people in the United States, of what the people want, which is not necessarily the role, like not the exactly the responsibility of the Supreme Court, but it is a part of it. So if their job.
Thanks, man.
Very cool. I appreciate that. Good to know.
Yeah.
And that was when the Clydesdales brought the case from the Budweiser factory to the White House. Cool little bit of history there. So besides cheers to that, that was the idea, is that the Constitution is a living document, right? And it is up to the Supreme Court to be able to interpret those laws in a modern fashion of what should this mean in today's context, looking at the legal precedent and then, if necessary, setting new legal precedent. So I think that the idea is that the laws adapt to the times, or interpretations of the law, interpretations of the Constitution adapts with the times. And if the justices aren't adapting with the times, they're not serving their purpose. That's maybe the narrative that I would spin on the affirmative, to say this is why there needs to be more regular turnover.
Yeah. Okay. So now there's a couple ways you could do this. You could go straight up and say on the negative. Oh, you know what? Before I do, I wanted to get the plan text out there, because like sometimes I really like details in plan text, and this is one of those circumstances where the details are kind of cool. Where the plan text that I saw, I'm like, that makes a whole lot of sense, is that they can serve no more than 18 years.
Okay. And
the reason for that is every 2 years you go through the process. So now it becomes, and there's 9 of them, so every 2 years you go through a complete cycle. And so every president in a single term would be able to get 2 justices. So it's coming, it's predictable. We don't have to, we're not waiting on pins and needles like when Scalia just like just died out of nowhere. And then it was like, and then Mitch McConnell like just withholds the vote, all by himself. Like he takes the power of selecting a Supreme Court justice away from the president, because I'll leave that up to you why he did it. I'll just put it that way.
So I guess I'm very interested in, I want to follow what it is that you're posing this plain text. So they can serve no more than 18 years. What about every 2 years? What do you mean by that?
Well, because there's 9 justices.
Okay.
So every 2 years there would be a vacancy.
I see. Okay. Got it.
Yeah.
Got it. Understand. So that's how you get every president term gets to. Understand.
Mm-hmm. And so what that does is turn this sort of like this system where we're waiting to see if they're going to retire or die into a little bit more, I don't know, it just seems a little bit more civil, like way of kind of looking at things.
A little more predictability.
Yeah.
Now
that's where it builds on the advantage. The politics advantage would be based on that story. Like I love those details when they can kind of work themselves into your story. It's like you propose the plan text in the first minute, and then you kind of return to some of the details that you brought up. It's like, and this is why I had that in the plan text.
Yeah.
Like kind of come full circle. It's really awesome. Really awesome.
So, and I think you probably still get some good advantage as to 18 years is still a long time to serve. That's still a lot of impact that someone would have on the functioning of the law of the United States. But you're not it's not a multi-generational term, right? Like they're not staying in office to impacting quite as much. So there's maybe a little bit of ground there. It feels ripe for a counterplan of just a little shorter or a little longer, right? Like the $1 Bob approach. Like
Yeah.
undercut.
I think there's a more clever counterplan there. I saw one where it's just rotate them between the superior court and the inferior court. So it wouldn't be a single, like there wouldn't be any term limits. You'd still get a lifetime appointment in the sort of court system.
Okay.
You know what I mean? But you wouldn't always be the justice seeing the case on the Supreme Court type of thing. So it kind of shuffles it more and more. You could still
Would
have,
this be between like the appellate circuits and then the Supreme Court?
those are the inferior courts, and
Okay.
so and I thought that was interesting that you have to
Okay.
like, and so sure, you can still have lifetime appointments. No term limit on that one. You get it in as long as you're still in good standing, but you're going to rotate in these cases. And the advantage to that is even the problem isn't term limits necessarily. It's like caseload. The Supreme Court has just been, we have 300 million people. You know what I mean? It's like we still have 9 justices overseeing all of the cases every single year. You know what I mean? It's like, come on now.
Yeah. And I think another part of the issue comes to just how timely something is. So the original idea behind the Supreme Court was that they're picking low-hanging fruit, that they are not actively legislating, right? Like their role is to take something up that is fairly well decided by the people or by like the public opinion or by the law, or at least is significant enough, but not too early. And I think that was part of original intent, where they have kicked some things back that they've decided like this is too contentious. This should go to lower courts, be that like a state's thing or like this is too specific an issue. But there have existed examples where things are too hot for the Supreme Court. It's still being kind of publicly debated and roiled up on. And I think that's maybe I would call that potentially ground for the negative, that if someone does have a term limit, they're more likely to take on a hotter case because they want to be more significant on something rather than waiting for something to be at the right time for the Supreme Court to weigh in.
Yeah, I don't know, man. Like that story, I get a little lost in that story. I'll be honest. Like,
I mean, the fact that between the Defense of Marriage Act and overturning DOMA, like lots and lots of cases of same-sex marriage and like gay marriage rights and all kinds of things came to the courts and were either like pushed back down to smaller courts or passed over. And I don't think that anyone would contend like that it didn't need a resolution. I think that it was that the court didn't find the timing of it right. I can't obviously speak for them. I'm not them, but that seemed to be the narrative that was being made, is like it wasn't until, God, what was that, 2016, that they finally were like, we're making this very clear. And by that point, like 30 something states already had passed it or had legalized gay marriage. Like there was a lot of movement. It had been a different political social issue. It was not as hot as it was in Clinton era.
I mean, I really want to try and make a discussion about like increasing the number of justices, but I don't.
Okay.
It's not really competitive and it's not topical, so it seems like a lost opportunity because a lot of people were talking about just increasing the number, and I don't know. Like I remember in history learning about when FDR tried to do that, and there was a big old uproar. And I'm like, what was the big deal? And now I'm kind of like, oh, I want to see what like I want to see that debate in real time this time. I want to like be there when it happens. And so,
what do you think that would do? Like, why would that make an impact? Why would you be supportive of that? I'm interested.
Oh, it's only just to, but like if I was on the affirmative, yeah. First off, you can handle more caseload that way. So it does take care of the caseload argument, but for the affirmative this time, right? So the affirmative doesn't solve for caseload. And I think that's I think, I don't know, the sort of just the numbers of things and quantifying the problem and stuff like that. It kind of helps in
How
that.
do you solve more? I would think that would actually,
No, because what they do is
paradoxically, that would lower the caseload. They could not take as many because any given hearing may now take longer because more people have more questions and more deliberation on it.
not all cases get heard. Like some of them are completely just written up and typed and stuff like that. There's not
Sure,
all.
but I don't think they like pass it off to like a justice. Like I don't think there's ever a single justice that writes one opinion, no one else sees it, and it goes back down, and therefore more justices mean more efficiency.
No, but being able to review cases, yeah, they do divide their
Oh,
labor
I
among
see.
themselves. You know what I mean? Where they kind of like how the cases are sort of managed.
Hmm.
They kind of take on different roles on different cases and stuff like that. When you got more of them, they could just review more of them. You know what I mean? It's like, and so um, it,
I wonder, like that seems because if you're going from 9 to 12 or something, for example,
mhm,
or I suppose you'd always want to keep an odd number, 9 to 13 or something.
yeah,
You would. I don't. If a case actually went to the Supreme Court, right? Like it was heard by the court, or it was heard by the
yeah,
justices. They still can only hear one at a time. Like unless
right.
we're going to create like little mini sections, like multiple Supreme Courts or something, they can still only hear one at a time. So I understand like maybe sifting through caseload, but that's all done by their clerks for the most part at this point, anyways, isn't it? So like just increase the number of clerks that each justice has.
Uh, I suppose. I suppose
Like
you
I
could.
guess I don't know the exact workings of it, but I can't
Yeah,
imagine like Clarence Thomas is covering through, dozens of cases a day. I just don't see that
yeah.
likely. Like I imagine his,
I don't
2 years
know.
out of Ivy League law school, hardcore, working 20 hours a day clerk is probably doing that.
Yeah, I don't know if I don't know enough about how clerk, like what the budget is, what the limitations on the number of clerk. I have zero. I didn't even man think to look up that. You know what I mean? But that's interesting. But anyways, like that, even that is kind of you see how it's like a tangent now. Like we've gone down this
Mhm.
trail, but
Yeah,
it's not topical and it's not counterplaying ground. It's a weird thing
sure.
that's like it's still related to the Supreme Court, but it's not part of this debate. And I don't know.
Yeah. So yeah, interesting path to go on it. I think one of the stronger negative arguments I would think on it is the likelihood of like the probability of bringing about like a particularly hungry justice. So like I guess if you were to weigh the likelihood of getting a bad justice now versus the likelihood of getting a bad justice post plan, right? If there exists a term limit, I would say that it probably increases the likelihood of a bad justice, if nothing else, but for the likelihood that they're campaigning and like pushing to get it.
Hmm.
Because I think there's more people that are maybe clamoring over that. I think once something is a lifetime, there's no longer this like need to prove and need to be significant. I think that's like one of my biggest criticisms for like the executive branch, the fact that we have 4-year term limits. Like most presidents actually lead for like 2 years of their first term, and then they just campaign for the next two to make it a second term. And so you don't really see like the merit of a president in their first term because they're just freaking campaigning for the next. So granted, 18 years is certainly a really long time,
Mhm.
but I would feel like that starts to create the same inherent pressure that other elected positions end up, mucking up with corruption and like, self-aggrandization.
I what that makes me think of is the thinking about the possibility of just going straight up on the negative, just going straight up like solvency attacks, because
Hmm.
ultimately, no matter what the advantage is, it has to be like better judgments, right? It's like that's the fundamental thing. It's supposed to be like these cases will be decided better. Is I can't like how do you not come to that conclusion for this topic in one way or another? There could be like a dozen different ways you get there, but that's the end result. And if your entire strategy on the negatives, therefore, the decisions are probably going to be just as crappy. Like if you have so like we're talking about reducing their tenure from 28 to 18, and somehow that's a magic number now. Like no, like we're gonna have people, like I miss like just winning on solvency. Just being like, you know what I mean? I miss people just winning on solvency because it's like when you kind of stop and think about it, it's like none of these things that we've discussed will probably make a damn bit of difference in the judgments that come out. You know what I mean? It's like there's
Yeah.
going to be like influenced by the political parties just as much. You know what I mean? It's like the difference between 18 and 28 is not that much.
So, I mean, does that mean that the neg just you're again like the Price is Right model, where like however many years the affirmative side limits it, you limit it by 1 year more, and be like, if they get any solvency, we get that percentage of solvency more.
I mean, I would only do that ironically, though. You know what I mean? It's like in the
Right.
end,
Sure.
I guess this is what when I say winning on solvency, I don't mean that's all you run, right? Yeah,
Oh, okay. I thought that's what you were meaning. It was like you just straight up case is order.
no. I mean when you get to rebuttals, you point out like, yeah, my best argument is this doesn't solve because it's the most reasonable one.
Mhm.
And I don't care if it's just defense. It's 100% defense. It's like they score 0 points on this shit. Okay, they don't score a percentage of anything. And so like I love that. It's like we get just one. It's like okay, yeah, you don't. You don't get one. You don't get any case that you could ever say would be better because that's an impossible thing to prove. An impossible thing to prove. You know what I
So
mean? It's like
if I had to do it, I would probably on the affirmative side, I would start looking up the most upsetting Supreme Court rulings, like the ones that just received absolute public outrage. And then I would pick out the justices that voted on whatever side pissed off the public the most. Now, granted, this is like, weighing decisions by the court of public opinion, which is not necessarily better, but even still, know your audience, know the judge in the back of the room. This is how I would practically do it as a competitor if I were in this round now. I would pick out the most upsetting like rulings in the last, decade or two or whatever, pick out the justices that voted against it and point out how many of them would have been out were this plan in place, right? Like we're in year 19 plus of their tenure on the court and they voted against it. Therefore, newer justices vote better. And I would probably just do some examples the opposite. I know that arguments of example are not great, but at least I would be able to start making the rhetoric of like, look, Defense of Marriage Act, Brown v. Board, like just pick out like the best cases that people really, really love, like things that did stuff that people are really stoked about, and point out like, okay, this was done by justices that were in their newer tenure. Now, granted, odds like there are probably with enough research time, you can probably find plenty of counterexamples, but I would just bank on the likelihood that the negative side didn't do that research.
right. Like, and I guess that's why I was thinking the exact same thing where maybe this is what defines me as a limited preparation debater because I guess I'm like, I don't think they have these cards. I don't
Yeah,
think
no, that's exactly what I would do. I would just dig up
you know what I
enough
mean?
examples, be like, what do you have that's better than these three, and just rattle off a whole bunch of cases. Like, do you really think that justices that are, super tenured are, making rulings better than these things? Because I have evidence to the contrary, and just kind of like bank it on that they probably didn't do that research.
Let's see. Here's the thing: you would have to do that in the 1AC. You'd have to do that in the first speech. You're the affirmative, right?
Mhm.
You have to
Yeah.
say that. And so, if you don't say that, oh, that's really fascinating. If you don't give me any examples in that first one, that's the argument I got in my back pocket, where it's kind of like, yeah, it's not going to be any better. Not
Well,
going to
I'm
be
guessing that that's my negative strategy too, though, is I would be looking at the exact same thing on the negative side. It'd be like green justices end up, brand new justices end up pushing through stuff that is not good, that pisses people off. And there, I would just run with that. So on either side, that would be my strategy in the hope that I could come up with in 20 minutes of prep time more than the other side and just throw them. Like, I don't love preponderance of evidence that are like debates, but that's probably what I would do.
What this makes me think of is some pretty sort of philosophical, critical arguments that you can make about progress. And because if you think about a lot of the arguments that you've been making, it's the assumption that like progress kind of goes in a straight line.
Hmm.
And so if you're like, okay, just because they're younger doesn't mean that they're going to be making better decisions. You know what I mean? And like the progress is criticizing the assumption of progress being a straight line. That's like the next level of debate. Like seeing that sort of argument, I think helps frame a whole lot of different positions, or at least the no solvency argument, like progress
Okay.
is
Yeah,
is
that's a good point.
fine. Yeah. And now you got a critique backing your no solvency position. But you're right. If you had some pretty damn good examples, I think it could overwhelm the critique.
If it really came to it, this is where I find some of the more challenging parts of debate is like I have my own personal belief on the subject of like, yeah, there should be term limits, but I don't have an effective enough argument that I feel confident that I could win around to that end. Like I've got to get all kinds of crafty with like various, debate tools, but like I feel this way and I would need to like do some more, I don't know, like digging to feel like I came out with something that would win a debate round beyond just like persuade another human being. Or maybe I shouldn't. And maybe I should just treat it as I'm going to sit in this room and persuade the person at the other end of the room my way. But debate doesn't really work that way.
Yeah. I don't know. Man, I love the no solvency argument. I love it. Like, I
I
think
mean,
people
does that mean that you come to the end of like, if at the end of the day you really think that there's not a better way to do it?
that there's no, all of them are pretty equally stupid. Yeah. Like
Okay.
we're a bunch of hairless monkeys trying to figure out what justice is. Yeah, and whether or not they do it for 18 years or 28 years, it's probably going to be just as stupid. Like, it's a really nihilist approach, but I guess that's, I don't know, on in limited preparation debate, you did find a way to basically punk people that didn't have a good enough AF. You know what I mean? And it was like,
Sure.
not, yeah, if they didn't have a good enough AF, then you could beat them on solvency and nihilism and stuff like that. You know what I mean? It's kind of like, because I mean, honestly, I think that's the best test of it, right? It's like you have to
Sure.
at least get people more motivated than a nihilist can get them demotivated.
That's a really good test. I actually really like that just from a philosophical basis. Like, are you more inspiring than skeptics hate this?
Okay.
I like it.
Yeah. All right. I think that's our time. All right, everybody. I'll be back in California next week, and we'll be talking again about debate related stuff. We got Tim and Jared. We'll see you.